Hello friends, greetings of the day. Today we are going to discuss a very interesting topic of law of torts, that is tortious liability of intermediary in e-commerce. The scheme of discussion can be summarized as under. We will start with introductory prologue, introduction to e-commerce, the conceptual dimensions of the term intermediary, the development of intermediary liability, the status of intermediary liability in the present scenario, analysis of the present legal framework for e-commerce, that is Consumer Protection E-Commerce Rules 2020, followed by the conclusion. Introductory prologue. As we all know, with the advent of the internet, online shopping has become very popular with Indian consumers. India is rapidly developing as a global supermarket for e-commerce. Simultaneously, it has furnished an expensive and practical marketplace for distributing counterfeit merchandise. According to a survey in India, approximately 20% of the respondents, or 1 in every 5 consumers, reported receiving a counterfeit product from a prominent e-commerce platform. Therefore, it is pivotal for us to understand the legal mechanisms behind e-commerce activities. In this lecture, we will understand the meaning of e-commerce and the legal paradigms of the Indian system to provide a safe and secure online marketplace for consumers. Introduction to e-commerce. Electronic commerce or e-commerce pertains to transactional activities involving purchasing or selling products via the internet or online platforms. E-commerce, which has witnessed a phenomenal surge in the online sales in the recent years, is among India's most rapidly expanding industries. The expansion mentioned above can be attributed to the endeavors of prominent electronic commerce platforms, including Amazon, Flipkart, and Meesho, which have effectively addressed the varied demands and inclinations of consumers in India. By providing a vast array of goods and services, including groceries, electronics, fashion, and education, these platforms have increased the accessibility and convenience of online purchasing for millions of Indians. In recent years, the worldwide e-commerce sector has substantially expanded, which has brought about a paradigm shift in consumer behavior and financial transactions. Due to technological advancements and the pervasive availability of the internet, online purchasing has grown exponentially across the globe. Numerous factors contribute to the substantial expansion and market magnitude of the worldwide e-commerce sector, including the pervasive availability of the internet and the proliferation of digital devices such as smartphones and tablets. Online purchasing empowers consumers to procure goods from an extensive assortment, compare prices, and complete transactions at their convenience, unencumbered by the physical store hours or geographic limitations. This element of convenience has significantly accelerated the expansion of the e-commerce industry. Implementing stringent cybersecurity measures and developing secure online payment systems have additionally bolstered consumer confidence in the online execution of financial transactions. Online shoppers can enhance the trust of their information by utilizing secure payment gateways and adhering to rigorous data protection protocols. Now we will discuss the conceptual dimensions of the term intermediary. Intermediaries, commonly called service providers or platforms, serve a vital function on the internet by acting as gatekeepers and facilitators of various services. These intermediaries are crucial in facilitating the extensive transmission of electronic data within the digital realm. In 2008, an amendment to the Information Technology Act 2000 was implemented to include provisions concerning intermediary liability. An intermediary is defined in Section 2 Subclause 1W of the IT Act as any individual or entity that acts on behalf of another person when receiving, storing, transmitting, or providing any service about an electronic record. This definition encompasses online marketplaces and auction sites as well. Regarding intermediary liability in India, Section 79 of the IT Act is the principal provision. In this provision, an intermediary shall not bear liability for any third-party information that it hosts or makes available on the condition that its role is restricted to facilitating access and does not instigate, set, or modify the transmission. In order to qualify for this exemption, it must also exercise due diligence when carrying out its responsibility in accordance with the IT regulations. Nevertheless, in accordance with the IT Act, an intermediary is not immune from liability if it facilitated, conspired, abetted, or assisted in the commission of illegal activity, or if it does not promptly disable or remove access to the illegal content after becoming aware, through actual knowledge or notification from the relevant government agency, that the data in question was being used to commit the illegal act. This provision for intermediaries is also known as a safe harbor, as an exemption from liability has been granted under this provision. Now we will discuss the development of intermediary liability. Shreya Singhal versus Union of India 2015 is a seminal legal case that emerged from the police apprehension of two women on Facebook, allegedly for publishing objectionable and offensive remarks concerning the demise of a political figure. The women were charged under Section 66A of the IT Act, which subsequently prompted a constitutional challenge to multiple provisions of the Information Technology Act. Section 66A was completely invalidated, but Section 79(3)(b) of the IT Act and Rule 3 Subclause 4 of the Intermediary Guidelines 2011 were overturned by the Supreme Court. The court interpreted the term knowledge to imply information that could only be obtained through a government notification or court order. As a result, intermediaries were not obligated to remove content from their platforms in response to a single user complaint that lacked a court order. Before this ruling, the term actual knowledge defined in the intermediary guidelines and the IT Act could have been construed as the intermediary exercising its discretion and determining what constituted illicit information. This adjudicatory function must be carried out by a court of law and not a private association to prevent private censorship from stifling online freedom of expression. This seminal ruling significantly modified the standard of knowledge required to establish liability for any content hosted or stored by an intermediary. Although the decision was initially formulated within the framework of free speech and the accountability of intermediaries like Facebook, its implications extended equally to e-commerce marketplaces. Consequently, without a court order, e-commerce marketplaces were not obligated to remove listings that brand owners claimed were counterfeit. As per the stipulations outlined in pertinent policies, rules and regulations, or as mandated by a court, e-commerce marketplaces were obligated to perform minimal due diligence concerning counterfeiting. In the legal case of Kent RO Systems Limited versus Amit Kotak 2017, Amit Kotak filed a lawsuit against Kent RO Systems Limited and eBay for selling water purifiers that violated his designs. The plaintiffs argued that intermediaries, including eBay, were obliged to exercise due diligence and following the IT Act and intermediary guidelines. eBay claimed to have eliminated all criticized products and pledged to do so again. However, the single judge determined that intermediary is only obligated to remove infringing listings upon obtaining actual knowledge of the matter as stated in the intermediary's guidelines. The court also noted that eBay hosts information automatically, making it impossible to order the company to screen all listings for intellectual property violations. Christian Louboutin SAS versus Nakul Bajaj 2018 was a case involving the plaintiff initiating legal proceedings against Darways.com, an online marketplace specializing in imported luxury goods in India. The plaintiff claimed that Darways, a company owned by Nakul Bajaj, was infringing on trademarks by selling counterfeit and compromised products. Darways asserted that it would not be liable for any infringement or counterfeiting because its role was limited to facilitating orders with sellers worldwide and shipping the products to their customers. The court determined that Darways was deemed responsible for trademark infringement and could not invoke IT Act's safe harbor provisions. In the case Amway India Enterprises Private Limited versus 1MG Technologies Private Limited 2019, the plaintiffs argued that their operations were governed by central government's direct selling guidelines, which forbade direct vendors from selling on e-commerce marketplaces without the consent of the direct selling entities. It was contended that e-commerce marketplaces were responsible for tortious interference with their contracts due to their facilitation of the plaintiff product sales via their platforms. The Delhi High Court's single judge ruled that the direct selling guidelines constituted law, and they governed e-commerce marketplaces as well as the direct sellers. The court determined that the plaintiff did not authorize the sale of authentic products if the source was questionable or untraceable to the direct vendor. However, the vendor must be an authorized seller and possesses the permission of the trademark owner in order to sell on the platform. The court also attributed considerable importance to platforms' value-added services, including transportation, delivery, and advertising. The FDI guidelines would only apply to e-commerce marketplaces once their actual role is determined. Students, the platform must conduct due diligence by establishing appropriate policies and taking action in response to notice from the brand proprietors. The court issued an injunction prohibiting platforms from reselling the plaintiff's products except for vendors who could provide written consent or permission from the plaintiff. The order mentioned above, issued by the single judge in the Amway Enterprises, the case was challenged and overturned in Amazon Seller Services Private Limited versus Amway India Enterprises Private Limited 2020. The direct selling guidelines could not be deemed legally binding according to the division bench. Furthermore, the court determined that the well-established principle of exhaustion was entirely relevant to the current situation and that e-commerce platform vendors could resell authentic and unaltered product without the manufacturer's or trademark holder's consent. Additionally, the court determined that the lawsuits were not initiated on the grounds of trademark infringement or passing off. Now, let us discuss the status of intermediary liability in the present scenario. Rule 3 of the Information Technology, Intermediary Guidelines and Digital Media Ethics Code Rules 2021 delineates the requisite level of diligence that an intermediary must adhere to in addition to the standards pre-established in the IT Act. It is required that an intermediary provides its users with a set of guidelines and regulations, a privacy statement, a user agreement, that users must be informed, among other things, that the rules and regulations prohibit disseminating any information that violates a patent, trademark, copyright or other proprietary right. Additionally, within 36 hours of acquiring knowledge independently or receiving written notification of such knowledge from an affected party, the intermediary is obligated to terminate access to the information above. Furthermore, according to Rule 3 Subclause 2A, the intermediary must prominently display name and contact information of the grievance officer on its website, mobile application or both depending upon the situation. Students, additionally, the rule specifies a mechanism through which a user or victim may complain about any infringement of the provisions above or any other issues concerning the computer resources provided by the intermediary. The complaint must be duly acknowledged within 24 hours of its reception, and it must also be resolved within a period of 15 days from the date of receipt. Furthermore, the newly introduced amendment stipulated that the central government must establish a grievance appellate committee within 3 months of the amendments taking effect. Additionally, it stated that an individual dissatisfied with the grievance officer's decision may file an appeal against that decision within 30 days from the date they received communication from the grievance officer. The grievance appellate committee shall expeditiously consider the appeal and strive to reach a final resolution within 30 days from the date the appeal is received. Although the laws mentioned earlier appropriately regulate the operations of online portals that qualify as intermediaries, numerous unresolved and unregulated practical issues are still elaborated upon. Analysis of the present legal framework for e-commerce, Consumer Protection E-commerce Rules 2020. The National Consumer Helpline of India is a crucial tool for e-commerce business operating in India. It provides guidelines for online companies, including the identification of top designated functionary or nodal person of contact who lives in India and the clear and easy to find information about the company's legal name, headquarters, website and phone numbers of both the customer service team and grievance officer. Students, e-commerce companies must also establish a convenient way for customers to file complaints, considering the number of complaints they usually receive from India. They must also hire a grievance officer and publicize their contact information on their website. If an e-commerce company sells imported goods or services, it must list the name and the contact information of any importer from whom it bought those goods or services or who may sell them on its site. It is also mandated to provide information about sellers that is clear and easy to find, such as the name of the business, whether it is registered or not, its address, customer service number, ratings or feedback collected about the seller and any other information needed to help customers make an informed decision before they buy. Students, e-commerce businesses must also join the National Consumer Helpline of the central government. No e-commerce company can charge cancellation fees to customers who change their minds after confirming their order, unless the company itself pays the same fees if they cancel the order for any reason. Online marketplaces have specific responsibilities. They must follow subsections 2 and 3 of the Information Technology Act and the Information Technology Intermediary Guidelines and Rules 2021. Marketplaces must require sellers to agree that the descriptions, pictures and other content about goods and services on their platform are correct and match the item's appearance, nature, quality, purpose and other general characteristics. In addition, marketplaces must provide consumers with information regarding the seller from whom they made a purchase, including the principal geographic addresses of its headquarters and all branches, the name and details of its websites and email address, and any other information necessary for communication with the seller for effective dispute resolution. Additionally, they must provide a ticket number for each complaint lodged so that the consumer can track the status of the complaint. E-commerce marketplaces must provide clear and easy to find information about terms of exchange, returns, refunds, delivery and shipment, modes of payment and grievance redressal mechanisms for consumers to make informed decisions. Students, they must also include information on available payment methods, the security of those payment methods, fees or charges payable by users, procedure to cancel regular payments under those methods, chargeback options and the contact information of the relevant payment service provider. Students, e-commerce entities must keep records of relevant information that can be used to find sellers who have repeatedly offered goods or services that have been taken down or access to which has been disabled. However, the e-commerce company doesn't have to stop the seller from using its site because of this sub-rule. It can do so if it wants to. Buyers in a marketplace must not use unfair business practices, pretend to be customers, post reviews about goods or services, or lie about the quality or features of any goods or services. Sellers cannot refuse to take back goods, withdraw or stop services that were bought or agreed to be bought, or refuse to refund payment if payment is made if the goods or services are broken, inadequate, fake, or don't have the qualities or characteristics that were promised or agreed upon, or if they are delivered later than the agreed upon. Sellers must have a written agreement with the e-commerce site before making the sale or offer. Appoint a grievance officer to handle customer complaints and ensure all things happen. They must also provide e-commerce marketplace with necessary information such as the total price of goods or services, the breakup price, the required and optional charges, notices and information required by law, the goods expiration date, necessary information about the goods and services being sold by the seller, the name, contact number and designation of the grievance officer, and the names and details of the importer along with the guarantees about the authenticity or genuineness of the imported goods. Students, online stores that sell goods or services outright obliquely claim them to be the accurate or promise to be confirmed will be held legally responsible for any claims about the realness of those goods or services. Breaking these rules will result in penalties under the Consumer Protection Act of 2019. Clear and easy to find information about terms of exchange, returns, refunds, delivery and shipping, as well as any guarantees or warranties that apply to those goods or services is also essential. Students, inventory e-commerce companies have specific duties and obligations, including providing accurate information about returning items, exchanging items, and making informed decisions. They must also avoid lying about the features or quality of goods or services. However, there is a lack of fair secondary responsibility rules to determine what intermediaries know and how they behave. The reasonable man test, which assumes computers to have the same level of knowledge and awareness as humans, is often used in ISP cases in the United States and EU. Now, coming to the conclusion, it should be noted in conclusion that online middlemen are not people but computer programs. The analysis of link between the supervision and control does not work. Tort law helps separate people who are responsible from those who are not. The reconciliation of secondary liability through tort law in different e-commerce situations show that the courts focus on the reason to know test instead of looking at the issue from the point of view of an internet intermediary's technical understanding. Furthermore, considering the cases above, it could be affirmed that the causation part is not taken into account, which links the facts to the case and gives the judge some freedom in figuring out when the damage was done in the chain of events. The reasons for responsibility are not good enough, and the courts have to use a negligent theory to determine how responsible the internet intermediary is. Not letting an internet service provider in would be the same as the turning off the power or computer running systems, and some steps taken to take down an intermediary may be more intrusive than others. Additionally, current laws and case law require material to be filtered and watched, which may go against the human rights like privacy or freedom of speech. To gain more certainty, clarity, and consistency, the courts should look at tort law aspects instead of just reasons for the analysis and the length of their opinions. The more tort law used in the secondary liability analysis, the more accurately it can be shown that online middlemen are to blame for illegal e-commerce activities. With this, we come to an end of today's lecture. Thank you so much for the patience listening.